We are on the record in the matter of People versus Latavis, Thornton. This is case 25-0203-FY, and may I have appearances for the record, please?
George and Ed on behalf of the people, Your Honor.
Thank you. And?
I'm Melissa Vachon with the Office of the Public Defender. Your Honor, I would note for the record that I am present and I did speak with Mr. Thornton. However, he is declining my representation at this arraignment.
Okay. And Mr. Thornton, could you state your name for the record, please?
I will object to being called Mr. Thornton. I am, for the record, my name is Shers. I am here as legal representation for Latavis Thornton, which is a nonprofit organization.
Your Honor, I'm looking at his file from 2022. I think he was sent to competency back in 2022, and it looks like that's going to be the same issue today. It's my understanding that he might have a bench warrant out for his arrest for sentencing. He pled guilty to, I believe, attempted R&O in November 8th of 2022, but he failed to appear in December 2022. And looking earlier in the files, I believe he was sent to competency as well. And it looks like this is going to be the same issue. So if the court is inclined to send him to competency, I'd ask for that.
Objection again, Your Honor.
Everything comes through me. You're going to get your turn. Okay. But I have to run this in sort of an organized fashion, in part for you, because if you want to appeal, you want a transcript that is coherent and readable. Okay.
I'm sorry. I don't know. Were you speaking to me or
yes,
to
sir,
Mr. A?
Mr. Thornton. So if you want to appeal,
I just want the record to be correct, and there was no objection. There was no objection to the statement that I made about Mr. Thornton, about Latavis Thornton being a nonprofit organization, and I was just objecting the points that the attorney prosecutor made.
Okay. But there aren't objections at arraignment. There aren't objections at arraignment. And I am going to call you Mr. Thornton because that is the name that you have been identified as, and that is the name the charges are under. No, Mr. Thornton. So, I mean, the other option is to call you defendant, which is true. You are the person defending yourself, but that sounds kind of rude. So I'd rather call you Mr. You have, under the Constitution, a Sixth Amendment right to know the charges against you. So we have this hearing for that reason. So I want to make sure that you get all of your rights and know everything that is available to know about this case right now so you can defend yourself. That's the whole purpose today. To give you the information you need so you can defend yourself with or without counsel as you wish, okay? We're going to do 5 things this afternoon. First, I'm going to read the charges against you, including the maximum possible penalties, because you have a right to know them. Second, we're going to talk more about your rights. Then, I'm going to enter a not guilty plea on your behalf. I'll give you the opportunity. Well, no, sir. So just a minute. Okay, so you're going to have the opportunity. You can stand mute or plead not guilty. We'll come to that in a minute. Okay, so that's the third thing we're going to do. Then we're going to talk about dates when you return to court. You're going to get those in writing. Lastly, we're going to talk about bond or bail. Okay, so.
Can I please?
Because here's the thing. I don't want to be disrespectful to you.
Right, absolutely.
I know it feels disrespectful, but here's why. Here's my concern. I don't want you to say anything that could come back to haunt you later. So that's why, and this is true of every arraignment I do, I tell people right at the beginning, if you try to speak, I'm going to shut you down. And it's not to be disrespectful, and it's not because the case has already been decided. It's to protect your innocence and your interest going forward. So for that reason, I'm going to do most of the talking here.
That's fine, Your Honor. I'm fine with you doing most of it. But please, to protect my free speech. Could you please not mute me? I have no intentions of disrespecting your courtroom. If I speak out of turn, could you just simply let me?
Buckle up, because this isn't your everyday courtroom clip. This is peak sovereign citizen theater star. Today, we're watching a man named Latavis Shers Thornton argue that he's not actually himself. That's right. According to him, Mr. Thornton Asterisk is merely a non-profit organization, and he is simply here on its behalf. Oh, and he also insists the court has no authority over him because, paperwork magic. But here's the twist. This judge, he's not playing games. He's patient, methodical, and armed with the Constitution. You're about to witness a masterclass in judicial composure and maybe a little comedic tragedy.
And that something I say could, like you said, come back and haunt me. I'm well aware of that for Latavis Shers Thornton. However, I do still need to express correctly, and if I'm capable of settling this matter now, why can't we do that? I have more than just the Sixth Amendment right. I have a plethora of rights that are granted to me from God, the Human Declaration, from the Constitution, and so forth. There's a plethora of rights that have been granted onto me. So I don't just want to rely on the few far in between. I would like to rely on all my rights and abilities, and if possible, take care of all these matters in the most dignified and respectful way to keep the court's dignity and my dignity as a man. And furthermore, as a preservation of my innocence, I would like, until proven guilty, I believe that is pertinent that the innocent factor be imminent here.
Absolutely. So here's what I'm going to tell you. And I tell this to everyone at this stage. The most important thing I can tell you this afternoon is that you are innocent. You are innocent unless you remain innocent unless at some point you plead guilty or are found guilty beyond a reasonable doubt at trial. And I say unless for a reason, because it's different than until. Until means something's going to happen sooner or later, right? We'll be here until Saturday. Saturday is going to happen. Unless means we don't know what's going to happen. And in your case, we don't know what's going to happen. You haven't seen the evidence. Okay, I'm going to keep going through this, and then I'll acknowledge you in just a minute. You haven't seen the evidence.
Okay.
No attorney has seen the evidence. The court hasn't seen the evidence. So you remain innocent unless you plead guilty or are found guilty beyond a reasonable doubt at trial. And now I'm going to read the charges against you because you have a right to know them. Okay, you can't really defend yourself unless you know what you're accused of. Maybe you remember being a little kid and going to the principal's office and not knowing what you might be in trouble for.
In trouble.
No? Okay. Well, you were probably a better little kid than I was. But I'm going to read the charges against you. It's going to take some time reading all the way through them.
Before you get to reading, can I make one statement, please?
Well,
Your Honor?
You can, but let me read through these first, okay? Let me read through these first because I want to make sure I cover everything. The other thing is judges use scripts. And the reason we use scripts is to make sure everyone gets all of the information and to make sure we treat everyone the same.
I'm aware of that, Your Honor. And that is why I feel it necessary for me to make certain things known for Latavis Shers Thornton, for that the script so we can stay in honor. Once again, I have no intentions on dishonoring the courts. I'm even here to surrender all of the interests of Latavis Shers Thornton to the courts. I have those full intentions.
This is the hill they choose to die on. In their world, using your legal name somehow binds your sovereign soul to a corporate entity owned by the state. It's pure pseudo-legal fantasy, but to them, it's gospel. Notice how he quickly pivots into introducing himself as legal representation for a nonprofit organization that happens to share his name. The judge has barely spoken, and already We're in Wonderland.
Really a nonprofit organization, and I am not a surety for it. And it is a company, and it does not profit. And so with that information, I understand that the script goes a little different, and I understand that I understand me now. I have the right to let it be known that I'm not the surety, and nobody has. I'm sorry, and
Okay. All right.
Yes,
So
ma'am.
here's
Your Honor.
here's the
sorry.
thing. That's okay. That's not an issue. So here's the thing. I don't know if you remember when a guy named Mitt Romney was running for president some time ago. And he said, and he really upset people with this, he said, corporations are people, my friend. And a lot of people made fun of him, but corporations are people. So that LLC would be a person in the eyes of the law. But a person does not become an LLC. But regardless, I'm going to read these charges because you have a right to know them. So in count 1, you are accused of police officer assaulting, resisting, and obstructing, contrary to Michigan law MCL 750.81D1. This is a felony punishable by up to 2 years in prison and or $2,000 in fines. In count 2, you are accused of assaulting, resisting, or obstructing a police officer. This is, again, a felony.
Yes, the plot thickens. The prosecutor casually drops a bombshell. This guy's been here before. Not once, but twice for competency evaluations. That's legal speak for, we've questioned whether he even understands what's happening. And judging by the word salad we just heard, that concern seems valid. What's wild is that even after all this, he's back, armed with the same delusions, ready to represent himself again. You can almost see the judge's patience meter ticking down like a countdown clock.
Punishable by up to 2 years in prison and or $2,000 in fines. Lastly, in count 3, you are accused of, again, assaulting, resisting, or obstructing a police officer. This is, again, a felony, punishable by up to 2 years in prison and or $2,000 in fines. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D6 for another violation arising from the same transaction. And this is alleged against the peace and dignity of the people of the state of Michigan. Now we're going to talk about your rights. You have the right to an attorney, and today Attorney Vachon is standing by. If you can't afford an attorney, the court will provide one for you, and we have superb public defenders in this court. That said, you can hire any attorney you wish. You would have to pay them, but you could choose whomever you wish. Now, there is an option for you to represent yourself, and we'll talk about that more at a future court hearing, okay? You have the right, as this case goes forward, to have these charges heard at a trial. And at that trial, the prosecutor would have to bring evidence against you. You could question that evidence, and you could question any witnesses the prosecutor called. You could call your own witnesses. And if they didn't want to appear, the court could issue a subpoena and the court could make them appear. At a trial, you could testify on your own behalf, or you could remain silent. And if you remain silent, no one could use that silence against you. At a trial, you could bring any evidence you wished, or you could just sit there, because it's the prosecutor's job to prove guilt beyond a reasonable doubt. And perhaps most importantly, and you know this one, this is your Fifth Amendment to the Constitution, you have a right against self-incrimination. And that means no one can do anything that forces you or tricks you into making yourself guilty. Now, how do you wish to plead?
I don't, you said a lot, so can I address them part for part? First,
No, not right now. So here's what I'm gonna do. Here's what I'm gonna edge.
Judge's genius shines. Watch how he refuses to take the bait. He doesn't argue the logic of, I'm not Mr. Thornton. He just calmly explains that's the name on the charge sheet. Translation, you can call yourself the Church of Cheeseburgers if you want, but the warrant says Thornton, and that's who's in custody. The judge even offers to call him defendant, which sounds cold, but he's being tactful. The man before him wants a fight, Instead, the judge gives him procedure. That's how you disarm a sovereign citizen, with politeness and paper trails.
Have you pleading guilty to all those charges? We've got some back and forth here. It kind of sounds like we're underwater. So a plea would have you pleading guilty to those crimes, 3 felonies, without having seen the evidence against you. So you can stand mute and the court enters a not guilty plea, or you can say you want to plead not guilty and you would be not guilty. Then what happens next, and here's why, then you have a chance to get the evidence against you and to consider it. And I think that's what you want to do, because that is your hard-fought constitutional right, among other things.
It's a bit more to it, Your Honor. That's the issue. So I will, based off of the things that you stated, that's not what my understanding is. From my understanding is I was attacked by some people and I was protecting
Sir,
my life.
I know you don't want my representation, but I would advise.
No, ma'am.
I would advise that you not talk about anything that happened.
Please don't, ma'am. I appreciate that. I'm aware of why you're doing that, but I'm aware. Like I said, me and the judge, I told her something that I might say could come back to haunt me. I'm already aware of that. So thank you so much, Miss Melissa, but please do not intervene. Once again, back to you, Your Honor. From my understanding, I was assaulted, and I am Shoulders. Once again, I have never told anyone. Wait, I don't want you to mute me, Judge. This is going back to this situation. Okay, thank you. I never told anyone.
Here comes one of the biggest misunderstandings among sovereign citizens. I have free speech in court. No, you don't. Not in the way you think. The courtroom is not a YouTube comment section. Judges have the authority to control the proceedings to maintain order and fairness. When the judge says, "I'll mute you if needed," he's not violating rights. He's maintaining the legal integrity of the hearing. But these guys here mute and think tyranny. The irony? Thornton's rambling free speech is the very reason courts use the mute.
That I am Latavis Thornton. Not one time. I have reiterated. I am Shoulders, Latavis, not just to you, Your Honor. That's so to be redundant for the record. Okay. I have reiterated that Latavis Thornton is a nonprofit organization. I am not a surety. I am Shoulders. I am appointed to be an administrator for Latavis Thornton. No, that's why I'm here, but not a surety for Latavis Thornton. Furthermore, Your Honor, my understanding is I was attacked and assaulted, and I'm not sure if I could let that be known to you so that we can make that case come about, because I would like to seek forward that using the evidence from all the evidence that they have gathered. I would like to use it in my assault case against East Lansing Police Department and its agencies.
Okay, so we have a couple different options here. First, the court is going to enter a not guilty plea on your behalf, so you can pursue that at a hearing where we can bring in evidence and that sort of thing, okay? Secondly, you have—
Here it comes. The holy trinity of sovereign nonsense, God-given rights, the human declaration, whatever that is, and a cherry-picked constitution. It's like they think citing random documents creates an invisible legal shield. This is the sovereign citizen's favorite move. Overwhelm the courtroom with philosophical word soup to appear knowledgeable. But the judge? He's playing chess, not checkers.